Welcome to Legalized Negligence, where we talk about Florida Statute 768.21, subsection 8, which pretty soon subsection 8 may not be a thing anymore. Today is January 20th. It is currently 1:27 Florida time. Yesterday, the Senate released the amendments to Senator Yarborough's SB248. And I spent a considerable amount of time last night looking it over, and then a considerable amount of time this morning looking it over, and thought I'd share my opinion of it with you. As always, I'm not an attorney. I just have a vested interest in getting this law changed. My mother died back on May 20th of 2020 because a nurse neglected to leave her fall prevention bed alarm on, even after she was put on notice that she had violated the safety policy. She still left the bed alarm off, and my mom tried to get out of bed and go to the bathroom. And when she did, she fell. And it took them several minutes to realize that she had fallen. A passerby, somebody who was walking by her room, heard her screaming in pain, and they came in to the room and got her back in bed. She had suffered 5 broken ribs, and she spent the next 18 days bleeding internally while the hospital ignored her. And even though the Department of Children and Families found the nurse negligent on 7 counts, the Department of Health said that she wasn't negligent. So for all you Floridians, this nurse is still practicing her brand of nursing care in Florida. And we have been trying to get the legislature to change this law, subsection 8, so that these kinds of things won't happen, and so that these medical licensees will be held accountable. But from what I'm reading, it appears that the lobbyists are winning. So what I'm going to do is walk you through these amendments that are going to be heard on Monday when the Senate reconvenes. And it still has to go through, this is just the Judiciary Committee. It has to go through the Judiciary Committee. Then it's got 2 more committees that it's got to go through before it's finally heard on the floor of the Senate, if it's heard on the floor of the Senate at all. And there also has to be a companion bill in the House that reflects the same things that this bill supports. And so it has to pass both the House and the Senate before it would go to the governor. I'll reserve my thoughts on all of that for the moment. And I'm probably going to have to do 2 or 3, possibly 4 podcasts to go through this whole thing, because it's quite complicated. We got what we were looking for. They struck subsection 8, and they made it possible to sue for non-economic damages, but there's sure a whole lot of hoops that you got to jump through to get there. And all we were asking for was them to strike subsection 8 and put us back on equal footing with everybody else in the state of Florida who can sue for non-economic damages without all of these caps. So I'm going to start off by sharing the actual amendments that came out yesterday. And I'm not going to spend a whole lot of time going through this because it gets rather complicated. But what I did this morning is, if you scroll through these amendments, you'll see these sections. We'll go down here to a big section where it's easy to see, where you see all these strike throughs. And these areas where you see the line drawn through this is old language, and the strike through means that gets taken out. And then in sections where you see how much they took out. But here's a section. Look at line 75, where there is a line underneath some language. That means that's the new language that's going to replace it. So the strike through means it goes away. The underlines means that that's new language, and if it doesn't have anything, a strike through or an underline, it just means that that language is there now and is going to stay. This document is 16 pages long. What I've done is I've compressed that down into about 7 pages, which I will now put up on the screen and share with you. And what I did is I took out all of the places where it struck out old language, so you don't have to look at that. And I've only left in the places where it still contains the new or the original language or adds the new language. So it reads as one document versus having all that stuff in there. Now, there is a section of the amendment where it says whereas, then it gives you a whereas. What that whereas means is because. So I replaced the word whereas with because it just makes it easier for the layman to understand. It kind of takes out all that legalese and puts it into something a little bit more readable. So I've titled this section of it, Senate Justification, Excuses for SB 248 Amendments. And one thing that I would like you to notice as I scroll through all of these reasons that they are proposing the amendments, the because part of it, I want you to notice that there is nothing here that relates to the rights of the people or the protections of the people. So I'm just going to take a moment and read through this. It's really pretty simple. And the bolded sections that you'll see are the parts that I want you to pay particular attention to. Because the legislature finds that expanding the right to recover non-economic damages for wrongful death caused by medical negligence furthers an important state interest of promoting accountability and adherence to the applicable standards of care, and because the legislature further recognizes that the expansion of the right to recover damages must be balanced against the important state interest of minimizing increases in the cost of malpractice insurance and promoting the availability of quality healthcare services. So they have two interests here. The state has two interests. Number one, it has an interest in keeping medical malpractice insurance rates down. And the second is so that the people have availability to quality health care. Third one, because the legislature finds that limitations on non-economic damages in medical negligence cases further the critical state interest in promoting the affordability and availability of healthcare services. Again, state interest, not people's interest. Because the legislature finds that the cases of a state of McCall v. United States and North Broward Hospital District versus Gallatin, which I pointed both of those out to Senator Yarborough earlier, which invalidated the limits on non-economic damages, and here's the important part, were decided contrary to legislative intent and prior to case law interpreting the Equal Protection Clause of the United States Constitution and the state constitution. The case that they're referring to there is Mizrahi versus North Miami Medical Center. And that's where the Supreme Court of Florida decided that it did not interfere with our rights to due process or equal protection of the law, even though Justice Pariente and another justice questioned whether or not the medical crisis continues today. So we'll go on to the next one. Because the cases of Estate of McCall v. United States and North Broward Hospital District versus Gallatin are inconsistent with the decisions of other courts addressing limits on damages. There you go, what I just said a minute ago. Because the legislature finds that the state has the highest medical malpractice insurance premiums in the nation and is in a sustained and continuing crisis of affordability with respect to the price of medical malpractice insurance. Well, like I have said 100 times, and I have pointed out to every senator and every representative that I've written to, if you've got a crisis that was back in 1990 that was supposed to be solved with subsection 8, then that subsection 8 statute failed miserably because you've still got that same crisis going on today. Is it possible the problem lies in another area? Maybe, and this is just my opinion, maybe there's so much malpractice going on in the state of Florida that the insurance companies can't keep up with it and they have to keep raising insurance rates. An easy way to understand that, imagine if your family members keep getting in auto accidents and your insurance company keeps raising your rates. I mean, it's that simple, you know. Let's move on. Because the legislature finds that having the highest medical malpractice insurance premiums in the nation is causing physicians to practice medicine without malpractice insurance, begin medical careers in other states, pursue opportunities to practice in other states, abstain from performing high-risk procedures in this state, and retire early from the practice of medicine. Again, let's not blame them for the negligence that happens. Let's just say that we've got all this malpractice going on in the state of Florida, and the way that we're going to resolve this is by keeping people from suing for damages. And I'll expound on that in a minute. It looks like we might actually get the opportunity to sue for non-economic damages, but it's not going to be enough for an attorney to want to take on the case. So they really haven't done anything but pat you on the head. Because the legislature finds that the crisis of having the highest medical malpractice insurance in the nation threatens the quality and availability of healthcare services for everyone. Well, you know what? If you got rid of that 4% of the doctors who cause 42% of the malpractice payouts, maybe you could solve the problem then. If malpractice wasn't occurring, people would not be bringing malpractice cases against negligent doctors. But for some reason, the Senate can't seem to see that. Because the legislature finds that the rapidly growing population and the changing demographics of the state make it imperative for the state to have a legal environment that helps to attract and retain physicians. Gee, I've heard Florida has been referred to as a second chance state, meaning that doctors move from other states where they've been found guilty of malpractice, and Florida accepts them. And now Florida is giving them a free pass by making it next to impossible to sue for malpractice. Let's move on. Because the legislature finds that there is an overpowering public necessity to ensure that physicians practice medicine in this state. Once again, the public needs versus the individual right to have access to the civil courts and to have a jury trial. Because the legislature finds that there is also an overpowering public necessity to enact policies that prevent medical malpractice insurance premiums from being unaffordable and continuing at crisis levels. I'm not going to repeat myself. You know what I have to say about that. Because the legislature finds that limitations on non-economic damages in medical negligence cases further the public interest or further the public necessity of making quality health care available to residents of this state, ensuring that physicians practice medicine in this state, and ensuring that those physicians have the opportunity to purchase affordable medical practice insurance. Those are all the reasons that they wrote SB 248, that they're adding these amendments, which we're going to get to here in a minute, that they're adding the amendments to SB 248. It's all about preventing the doctors from being held accountable for the negligence that they commit. So don't be fooled. Yes, they're about to give you, if the law passes, if it makes it through all three committees, it's heard on the Senate floor, has a matching bill in the House, and the governor signs it, they're going to strike subsection 8, and they're going to give you the ability to sue for damages. But again, those damages are capped so low that no attorney is going to take the case. It takes, and I've heard estimates anywhere from $200,000 to $300,000 for an attorney to put on his case. And when your damages are capped at or below that, no attorney's going to do this. He's going to say, man, I barely break even on this. There's going to be nothing left. And here's the important part about being able to get into the civil courts. If you can only go through the Department of Health or ACA to find a doctor or a hospital negligent, and they don't find him negligent, and that doesn't necessarily mean that he wasn't, then the case never gets to go public. People don't get to hear about it because the Department of Health and ACA keep all of that under wraps unless the doctor is found negligent. That's when it comes to the forefront. However, if it could get into a civil court, then we could bring that issue before the people, and the state of Florida, meaning the legislature, the governor, and the judiciary, would know that they would know more about how many cases of malpractice are happening. Right now, they get swept under the rug. So even though they have a number of cases that they say were reported, you don't know how many are actually out there because so many of them go away. This next section, I've broken down, this was all one long paragraph, but I've broken it down into its components. And what these are my words, the ones in red. The Senate intends to pass a bill which will accomplish the following. And then it tells you what the legislation is how they're going to go about accomplishing their goals that I just read to you, or the reason for doing this that I just read to you. And this, if you read through it, it tells everything that's in the legislation a little further down. But they cite a bunch of laws. You have to look all those laws up and see what they say, how they apply. But then you get into the actual amendments themselves. And I've titled this section of it, "This is how the Senate will accomplish its goal." And now this is the actual wording of the amendments, but I have removed all of the language that they struck through because it just confuses it. I got it down from 16 pages down to 7 by doing that. So I'm not going to read all of this right now. I'm going to take this section by section in other podcasts, but I want to scroll down to a couple of very interesting parts of this, or very important parts of this. And I've highlighted them so that people can read this. Here we're talking about, regardless of the number of, okay, let me find the beginning of that sentence. Okay, notwithstanding subsections 2, 3, and 5 with respect to a cause of action for personal injury or wrongful death arising from medical negligence of a practitioner committed in the course of providing medical services and medical care to Medicaid recipient, non-economic damages, here's the part, non-economic damages may not exceed $300,000 per claimant, regardless of the number of practitioners who are liable for the claimant's damages, unless the claimant pleads and proves by clear and convincing evidence that the practitioner acted in a wrongful manner. Now, here's why that's important. In an administrative tribunal, like you have in the Department of Health or in ACA, you have to meet a clear and convincing standard of proof or burden of proof. That's 75%. In a civil court, you only have to prove a preponderance, which is 50 plus 1%. 51%, and you can find a burden of proof. But they've changed that. They're now making it where they've separated us again from everybody else. And now we have a higher burden of proof, a 24% higher burden of proof to show. Let me continue to read. The fact that a claimant proves that a practitioner acted in a wrongful manner, here's the important part, does not preclude the application of the limitation on non-economic damages prescribed elsewhere in this section. So even though you prove that, you're still capped. $300,000, you're still capped. Now, if an attorney is going to have to spend $300,000 out of his own pocket in order to bring the case, why on earth would he take it if he can only recover $300,000? It makes no sense. Here's something else that I found a little bit interesting. Under C, the term wrongful manner means in bad faith or with malicious purpose, or in a manner exhibiting wanton and willful disregard of human rights, safety, or property, and shall be construed in conformity with the standards set forth as in section 768.289A. Okay, think about that for just a minute. Consider that. There's nothing in there about negligence. That's the whole point of a negligence case. Here, he has to act with maliciousness, with malicious intent. He can't just be negligent. He has to intentionally do this. That's not the same as in a civil case. Let me see. There's so much here to go over, and I'm trying to keep this brief so I can break it down into several videos. Now, under number 8, actions governed by sovereign immunity law. God, that could be a podcast on its own. Subsection 8 of section 768.21 Florida statutes is amended, and subsections 3 and 4 of that action are republished to read. That's the part that tells you that they're going to strike subsection 8. So they gave us what we asked for, okay? But they gave you an awful lot of hoops to jump through, and they also redefined a lot of words. All right, and this is how where it says, and it shall read like this, and then it just goes on to talk about that we can now recover damages, but those damages are going to be capped. Here's a couple of things that I really thought were important. Let me find the beginning of this sentence. Up here under section 6, every medical malpractice insurer and every medical malpractice insurer rate filing made with the Office of Insurance Regulation on or before January 1, 2025 must reflect the projected changes in claim frequency, claim severity, and loss adjustment expenses, including for attorney's fees and any other change excuse me, indicated due to the combined effect of the applicable provisions of this act. And here's the reason: in order to ensure that rates for insurance accurately reflect the risk providing such insurance. That looks to me like they're probably saying if they want to make sure the insurance companies aren't charging more than to the doctor than they should have. Well, okay, that sounds good. The Office of Insurance Regulation shall consider in its review the rate of filings made on or after January 1, 2025, the projected changes in costs associated with the amendments to subsection or to section 766.118 and methodology and data that incorporate generally accepted actuarial techniques and standards to be used in its review of rate filings governed by this section. What they're being told that they have to submit to the state says here are the reason for that is not intended to create a mandatory rate increase or decrease for all medical malpractice insurers. This is the part that really gets to me. But rather to ensure that the rates for such coverage meet the requirements of sections 627.062 Florida statutes and thus are not inadequate, excessive, and listen to this, or unfairly discriminatory, and allow such insurers a reasonable rate of return. That pretty much tells me what they're interested in here. They want the insurance companies to not be treated unfairly. They don't want them to be discriminated against, and they want them to be able to achieve a reasonable rate of return. Well, isn't that what we've been asking for all along? To be treated fairly, to be able to access the civil courts like everybody else can in tort claims. I'm going to stop at this point and get this video uploaded, and then I'm going to pick up on the next video at section 7, where they talk about the Office of Program Policy Analysis and Government Accountability. So let me go ahead and thank you for joining this part. I'd like to keep these videos on this short because there's a tremendous amount to go through, and people don't have much of a attention span these days, and if these videos are too long, they're not going to watch them. So I'm going to go ahead and stop sharing this screen now. I'll pick it back up at section 7 in the next video, which I'll record today and try to get up. If anybody's still interested in going to Tallahassee on Monday, I don't know that you're going to make a difference. I'm not telling you not to do whatever you think is best, but I think that they've made up their mind. I think it's great that something finally looks like it might get through the Judiciary Committee in the Senate. But I also believe, like I said in my last podcast, I also believe that they've been writing these amendments since earlier in 2023. These amendments, I don't believe, came out after Senator Yarborough introduced SB248. This just seems a bit too complicated to me and too well thought out for them to have written these in the last 2 or 3 weeks. I think that they've been working on this all along. I think they've been listening to our stories that have made it to the news. I think they've been listening to our phone calls and reading our email. And I think they have crafted these amendments to fit every situation and scenario that we've shown to them so that the doctors and the insurance companies are afforded protection. And we're patted on the head and they say, okay, we've struck subsection 8, which you asked us to do, and you now have a right to sue for non-economic damages. And we go away thinking we achieved something when in fact, the caps on the non-economic damages are so low that we're still in a position no attorney will take the case. Now, there's a couple of things later on about the Department of Health and ACA that I'll get into, but I'm going to go ahead and get this video uploaded and stay tuned for parts 2, possibly 3.